Good morning. I'm Andy Stromitis. I'm co-chair of BFKN's Compensation and Employment Law Practice Group, and I would like to welcome all of you to our presentation, our Compensation and Employment Law update as we near the end of the year. As you can tell from our lead slide, we didn't exactly get it right with our subtitle, but hopefully we'll be able to provide you with some information here that you'll be able to use as you start to look into 2021 and what might be coming after this most unusual of years. For anyone who's joining us from Chicago, I hope that you've either had the opportunity to get outside or will do so later today and enjoy some of this beautiful weather. 60 degrees for the middle of November, it's not too bad. So hopefully you'll be able to enjoy some of that. On behalf of the firm and on behalf of our guest presenters at FW Cook, I would like to welcome everyone here. You know, at Barrick Ferrazzano, when we talk about compensation and employment law, we often refer to our practice area as being hiring to firing and everything in between. And sometimes that extends to things that come after the employment relationship has ended as well. We cover retirement plans, non-qualified deferred compensation plans, equity incentive plans. And we have some top-notch litigators who are focused on the employment arena so that if things do go wrong, we're there to help on that side of it as well. Joining us today from FW Cook are Dave Yang and Michael Kenny. And FW Cook is a national and international independent executive compensation consulting firm. As many of you who have worked with us before know, we like to pride ourselves on being a high-touch law firm. We like to have multiple points of contact for all of you out there to discuss your legal needs. And that's because we like to bring a team approach to everything that we're doing, because we think the various perspectives that everyone can offer help to give you better, more comprehensive legal advice. And that approach to the teamwork doesn't stop at our office doors. We like to partner with other firms out there. We like to work with other firms that can provide you with information that isn't necessarily what you would come to your lawyers for. And FW Cook is definitely one of those firms. While they are an independent compensation consulting firm, we work with them on various engagements. We come across them in all of our various work that we're doing for clients, and we view them as a reputable and knowledgeable source on executive compensation. So we're very happy that they've been able to join us today. You know, as we've been making our way through 2020, the phrase "what a year" certainly comes to mind. But I think at the end of the day, when we kind of take a step back and get over the fact that we're living through history, it's often the same thing as it's always been. It's one step at a time, one foot in front of the other. And maybe a common theme that's running through everything that's going on this year is just quite simply people. And as many of the participants on this presentation, not only the presenters, but you, the audience, understand, it's the people that make our companies what they are. And on the compensation and employment side of it, we're the ones who are typically focused on dealing with those people issues. So in a year like this that has presented as many challenges as it has, we get the added challenge of trying to figure out what all this means. So we hope that our presentation today puts some of this in perspective for you. On our agenda for today, we're going to talk to you about some of the latest compensation and employment issues. We're going to give you an update on trends in employment litigation. We're going to obviously speak about the impact of COVID-19 on your bonus plans and other business-related issues resulting from COVID-19. We even have a crystal ball session here for you today. We're gonna try and give you some look into what a Biden administration might mean for employment law. And then we're going to also touch on the ever-evolving topic of ESG and its relevance to all different kinds of companies. So before we get going, if just a housekeeping issue, if you have questions as we're going through this presentation, if you look at the bottom of your screen, at least on my screen, it shows up on the bottom, there is a Q&A tab. If you click on the Q&A tab, you can put questions in there. We'll try our best to get to the questions at the end of the session. If we don't answer one of your questions during the session, we'll make sure to follow up with you. And of course, you will have access to all of our contact information, so you can feel free to reach out to us as well. To start us off this morning on the substantive side of it, we have Allison Powers. Allison is a partner in our compensation and employment practice, and she is an employment litigator and counselor. She has spent the last decade plus handling high profile and bet the company type litigation for a diverse group of clients across the entire country. Allison is going to be giving you her insights on some of the current trends in employment litigation. So with that, Allison, take it away. Allison, you might be on mute.
Okay. Sorry, it said the host muted me, so apologies for that. I'll just start over. I was thanking you, Andy, for the opportunity to be on the webinar and to share my insights about this very dynamic legal landscape. And I was just starting to say that when we talk about employment litigation, there are a wide range of possible theories and laws under which employees could bring their claims. Many people are familiar with Title VII, for example, or the Americans with Disabilities Act, or the National Labor Relations Act. Of course, there's also a full buffet of state law complements to these laws and common law that is not codified. Today, I will be discussing trends that we have started to see as these last 7 months have been evolving in a COVID landscape, and what we can expect as we look forward to a new administration in Washington. To start off, I think it would be fair to say that the legal landscape is, as we speak, being shaped by a couple of forces. Next slide, please. Obviously, the pandemic predominates. It continues to impact not only how employees perform work, but we're starting to see that it's also changing how employees think about their relationships with their employers. And also we're seeing, just from an operational standpoint, changes to employees' access to courts and agencies. The next force is a political one. We have just gone through a very suspenseful election cycle, and it appears, although we still can't say for certain, that it will be a Biden administration. And in that event, Biden administration priorities will certainly impact regulatory agency enforcement priorities, legislation, and ultimately will drive litigation. Next slide. So I am going to share some numbers that have started to emerge over the first 3 quarters of 2020 pertaining to employment litigation. In general, I think there's been a lot of talk about, oh, employment litigation is certain to be busy, but the numbers are in, and I can get more specific about what we're actually seeing. Next slide. A company called Lex Machina, which is an arm of LexisNexis, recently released some data pertaining to federal employment law case filings, meaning cases that have been filed in federal courts in Q1, 2, and 3. And what their data shows is that for the past decade, so going back to 2010 and continuing to 2019, employment filings, so federal case filings of employment law claims under the variety of statutes, generally have been fairly steady, not a lot of big changes, always between 21 and 22,000 cases being filed every year until this year. Next slide, please. So what Lex Machina has been able to do is basically track all the filings coming through Pacer and tag them in a certain way. And while generally employment litigators have been thinking that there would be overall just a rush to the courthouse, in actuality, there has been a decline in actual case filings, and we are down approximately 16% for Q1 to Q3 relative to the typical trend, which is just, generally steady. So there are any number of reasons for this, but from my standpoint, there are several drivers. One, there is a definite downturn in agency action and issuance of right to sue notices, where typically to get into federal court, employees need to have administratively exhausted their claims, and they need that right to sue letter to get into court. The EEOC, for example, at the start of the pandemic and continuing through the summer, did not issue many right to sue notices. And so part of the decline might be just employees not having access to what they need to proceed. There's also less access to courts, as courts have closed and started to prioritize criminal matters over civil matters, for example. So it's been difficult to get into court and get in front of judges, although that is starting to change slowly. But for example, in the Northern District of Illinois, where I'm located, there were several extensions, I think totaling at least 60 days over the course of the summer, that essentially brought certain litigation to a standstill and just kicked many dates and deadlines out. Employees are just not as focused on suing as they are on simply surviving. So certainly, and I will talk about this in a moment, the lawsuits are coming, but in the thick of the pandemic, employees just were focused on slightly different priorities. There also, we believe, has been a shift from federal court to state court filings. And so some of the federal claims perhaps have shifted over to state court. It's very difficult to know if a case that was filed in state court may have been filed in federal court otherwise, but I suspect that there is some of that also going on. And then just the reality of the pandemic, and perhaps as a result of the other forces that I mentioned, there are more settlements. So instead of litigation, there has been more interest in just settling cases. So for all of those reasons, and perhaps even others, litigation filings are down significantly this year versus last year. Next slide, please. So in terms of looking at where in the potential types of claims the decline has been most significant, what we're seeing is that discrimination, harassment, and ADA claims have taken the greatest hit. And there are reasons for that as well. One being the shift to remote work. Claims like harassment claims probably thrive more in a situation where employees are in the same space working together. So there has been a big drop off in harassment claims. There's not as much need for workplace accommodations and not as many flashpoints as one might typically see in a workplace. Wage hour claims, though, are less impacted. So they're only down by about 5%. And a reason for that is a lot of retailers who have employees have continued to operate during the pandemic. And in all likelihood, that is where the plaintiffs are from, businesses that were able to continue their operations during the pandemic without much interruption. Leave issues are also less impacted, and that makes sense as well. Potentially because of law changes granting more entitlement to leave to certain employees. And on this point, I would add that going back to the accommodation point I made earlier, accommodation requests now are just more nuanced and a little bit more difficult than before. So accommodation requests are probably more likely to be in the form of a leave request. And the facts that need to be considered there, I think, have changed for a lot of employers. Retaliation claims are also not down as much as harassment and discrimination claims. And that is because this is a cause of action that is available under many different employment statutes, and plaintiffs are alleging claims based on events that they think happened during the pandemic. So I will talk a little bit more about that when I get into some of my future slides, but retaliation will be a very busy area for employment litigation. And then other facts I want to share just about the data not reflected on this slide is there are also fewer trials, and that should not be surprising. Trials are down, way down. So whereas there might be several hundred trials by now in 2020, there have been fewer than 100 this year. And it should also not be a surprise that it's just taking longer for cases to even get to that point. And that simply reflects the stay on litigation that happened during the pandemic. It was also reported that so far in the pandemic, there have been just over 300 cases that have a specific COVID fact pattern underlying the claim. And within those 300 or so, it looks like most were retaliation claims, as I just mentioned, followed by Family and Medical Leave Act claims, and then Fair Labor Standards Act claims. So very, very much aligned with what we would expect based on this data. Even though the 2020 trend has been reflecting a certain amount of decline, I think most employment litigators would agree that the cases are coming, and we're all anticipating a very busy 2021 and possibly beyond. Who knows how long the pandemic might last. So what I'd like to cover now is just where the cases are likely to be concentrated. So 5 subject areas that employers should be on the lookout for, and what the theories of the plaintiff's cases might look like. Next slide, please. So coming attraction number 1 is EEO claims with COVID-19 fact patterns. These types of claims will be premised on the gamut of EEO causes of action, whether it's alleged disability, age, race and or national origin, or family and medical leave caregiver status. And what this might look like is an employee who might not otherwise have considered themselves disabled, for example, might feel that in light of statistics around COVID and who has been identified as part of a vulnerable population, for example, that they now fit into the category of people who should be considered disabled or who should get special accommodation. And so we're expecting that there will be certain COVID-related disability claims raised. Similarly, and I mentioned a vulnerable population before, but age claims could increase. And employers should be very careful to not disparately select or target employees, even if well-intentioned, because of their age or any belief about their susceptibility to COVID based on age. Similarly, claims about disparate selection or impact of protected classes of persons based on race or national origin could increase. And a hot area is family medical leave and caregiver status. We put out a client alert a couple of months ago that discussed eligibility for leave under pandemic-driven laws, and employees are now, for example, eligible to take family and medical leave in certain circumstances to care for children who are now not attending school and where no other caregivers are available to assist. And so we might see just an increase in claims pertaining to taking a family and medical leave and actions that employers take when employees attempt to claim leave under either the Family and Medical Leave Act or the Family First Coronavirus Response Act, which extends certain leave benefits to employees who otherwise might not have qualified pre-pandemic. Next slide, please. So it's not really a coming attraction because, as I mentioned, wage and hour disputes have not really declined tremendously during the first 3 quarters of 2020, but more wage hour disputes are coming. And we anticipate that wage hour disputes will involve a variety of theories, but employer compensation practices are under scrutiny. People have a lot of opinions about what and how they should be paid for their work during COVID. And so we expect that there will be challenges to employer compensation practices based on employee pre and post shift activities, questions and challenges to pay practices around, should an employer pay for the time an employee spends going through a temperature checkpoint or other active screening protocol. And just again, reflecting the shift to work from home, there are going to be more claims where employees allege that they had off the clock time involving checking emails after established work hours. We also expect that there will be more cases involving claims regarding entitlement to on-shift meal and rest breaks in jurisdictions that provide for those. A lot of fact patterns will probably involve the shift to remote work and just modifications in employee schedules. And so employers should be on the lookout for that and should be partnering with their HR and outside and in-house counsel regarding those types of decisions. Similarly, on-call time and entitlement to expense reimbursement for telephone, internet, and other services needed to facilitate work from home will probably also come under scrutiny. Next slide. Coming attraction number 3, furlough and layoff claims. These have always been around as, there was at least one economic downturn prior to the pandemic, but pandemic-driven furloughs and layoffs were a major thing, especially at the start. And so we expect that there will be claims pertaining to how employers carried out those furloughs and layoffs. First, employees could allege general failure to comply with the notice requirements of the Worker Adjustment and Retraining Notification Act, known as WARN. It is a federal statute, but there are a multitude of state law mini WARN statutes that also exist. And so there could be a lot of scrutiny around WARN Act actions. And the one thing I would mention here is that under the federal act, which is solely enforced by by legal action in federal court, an employee need not go through administrative exhaustion, and so they can go directly to court. Written notice must be provided to affected employees when there's an employment loss. And several, who knows what number of employers, but employers may have been in a situation where they believed that the layoff or furlough, I think there's a lot of confusion over which one employers were even thinking to do, but some employers may have believed that they were taking a temporary action, but for a temporary layoff or furlough that lasts longer than 6 months, it is considered an employment loss. So employers may be in a situation where they believed, oh, I'll be able to call these employees back in 2 or 3 months, and now it's been 7 months and they have not, and may have failed to follow up with their WARN Act compliance in providing additional notices to employees. And so there could be lawsuits pertaining to that. We also anticipate that there could be discrimination claims based on disparate selection of employees for furloughs and layoffs. And then conversely, disparate selection of employees for reinstatement in the event an employer is in a position to return workers to the workplace. Next slide. Workplace safety suits. Those they're percolating and they're coming. Employees, as many of you know, have a lot of opinions about the adequacy of protective gear in the workplace and PPE. Employees have just a lot of opinion about, whether their employers are doing enough. And so the Occupational Health and Safety Administration, federal agency, is responsible for enforcement actions pertaining to workplace safety issues involving the pandemic. OSHA has put out guidance pertaining to that, and employees, I am aware, have been calling OSHA and reporting on employers where they don't believe that enough is being done to ensure employee safety. Similarly, there's a big battle involving whether or not employees would be covered for any losses and injuries under workers' compensation or whether they have other remedies. Some states have passed laws that pretty much limit employees' remedies to a workers' compensation scheme. So there probably will be a lot of activity involving workers' compensation claims. In Illinois, for example, there is now a rebuttable presumption of workers' compensation coverage for first responders and frontline workers. And here I would just note that the definition of a COVID-19 first responder includes any individual that was employed by a business classified as essential. And that obviously stretches well beyond healthcare or emergency services. And so employers need to consider whether they might be considered an essential business and what an employee's remedy might be in the event that they sue. There will be tort-based claims, negligence claims, and so on pertaining to workplace safety issues. And similarly, and related to the OSHA point earlier, retaliation and whistleblower claims are going to increase pertaining to employees' complaints about workplace safety. I added the final point about a vaccine because obviously we've gotten some news about a vaccine lately, and we know that one is on the horizon. I anticipate that when the vaccine comes, there could be lawsuits and just questions pertaining to who gets it, whether people got a vaccine fast enough, how they were, just how it was prioritized and rolled out. And so the vaccine issue is likely to become prominent in employment spaces as the availability of vaccines becomes more certain and employers consider returning employees to work and possibly requiring vaccines. Next slide. And the final point I wanted to make, this is my last coming attraction, it's unfair labor practice charges. And typically employers are thinking, well, I don't have any unionized employees. Why do I care about the National Labor Relations Act and unfair labor practice charges? But I just wanted to point out that the NLRA extends its protections to almost all private sector employees, regardless of whether they're a part of a union. And so there are concerns under the NLRA for everybody, pretty much. And to just say a little bit more about that, under Section 7 of the National Labor Relations Act, employees, whether union or not.
So perhaps Zoom is telling us that Allison is freezing up. They don't want to hear about this part of the presentation, I think. Okay, so is Allison frozen on everyone's screen and not just mine? Am I just talking over? Okay, so why don't we go, we'll go ahead and move on, and we'll get to our next segment, the joys of doing webinars. This is fun stuff, technology in 2020. So up next, and Allison was just about, at the end of her presentation, and hopefully we'll get her to come back on at the end so she can wrap up and give us any final thoughts if she needs to. But up next, we're going to have some discussion about COVID-19's impact on bonus plans and other business continuity type matters. Our presenters for this segment are Andrew Gordon, who is a senior associate in our compensation and employment practice. Andrew is, he has a bit of a unique background for an employee benefits attorney in that he is a two-time federal clerk, a federal court clerk, and he's a former litigator. So he brings a really unique perspective to what is largely a transactional practice. Along with Andrew is Michael Kenny from FW Cook. Michael is a principal in FW Cook's Chicago office. He has over a decade of experience with public and private companies of all sizes. Michael's clients include financial institutions, transportation companies, capital goods companies, and consumer discretionary companies. And so, guys, why don't you tell us a little bit about COVID-19 and bonuses?
Okay, thanks, Andy. Next slide. So unlike the financial crisis of 2008, in which all companies were generally negatively affected, COVID-19 has affected companies in very different ways. Several companies have faced headwinds while others have received tailwinds. And that's affected management and compensation committees' responses to executive pay actions. Today, we're going to be talking about, generally throughout the presentation, three different ways or levels of impact that companies have faced during COVID. We have the high impact category, the medium impact category, and the low or actual slight positive benefit category from COVID. In the high impact category, generally, we're talking about those companies from the energy, airlines, restaurants and hospitality, and certain brick and mortar retail industries. And then all the way down to the other end of the spectrum for the low impact category, we're talking about IT companies, e-commerce retail, pharma biotech, and consumer packaged goods companies. Next slide, please. So when COVID first hit, businesses were facing various liquidity issues. And so they started cutting dividends, reducing their CapEx spending, laying off employees and also furloughing employees. And so some companies had executives and their board of directors share in some of that pain that the other employees and also shareholders were feeling. Some of the pay actions that took place were mainly in those high impact industries, so consumer discretionary, industrials, healthcare, and in the energy sectors. And the pay actions that were taken generally for executives, there were salary reductions. And for board of directors, generally it was their cash retainers which were reduced, but in some cases, they also reduced their equity compensation. And the level of these reductions varied by the impact of the industry. So for instance, in CEOs, their salary reductions ranged from 25% to about 81%. For some of those hardest hit, CEOs gave up on a temporary basis all of their salaries. For the remaining named executive officers, those reductions were a little more muted and generally ranged from about 15 to 30%. And for directors, their reductions were fairly closely aligned with CEOs, and they ranged from approximately 20% all the way up to 100%. With the recent recovery, what we've seen is that many companies are now restoring their pay levels, and only the hardest hit are still carrying forward some of their reductions. Next slide. So beyond the liquidity issues, the conversation moved to annual incentive plans. Certain companies started to realize that the bonus plans that they set in February were possibly not going to be paying out based on financial performance over just a few months into COVID. So the responses really depended again on the impact of the particular industry that companies happen to be in. For those companies in the neutral to positive impact category, generally it's business as usual. So for their 2020 goals that they set for the annual incentive plans, they decided there was no need to worry. And as far as the annual incentive plans and long-term incentive plans, there's no need to consider even any downward adjustments. For those companies that were in the low to moderatively negative impact category, they reviewed the bonus plans and decided that the best approach was going to be a wait and see approach. Instead of considering modifying goals, they were going to let the annual bonus programs play out. And right now, what we're seeing is that management teams and compensation committees are discussing ways in which they're going to consider applying discretion if necessary. Since the recovery has started, some of our clients are seeing that their bonus plans are actually going to have payouts, and discretion is not even on the table anymore. For others, they're trying to figure out if there's ways that they can figure out how to adjust for COVID under their regular formulaic plans. In most cases, that's not going to be possible. And so they're coming up with a narrative for what the story is going to be for applying positive discretion. And then for those companies that are in the hardest hit category, initially they thought about resetting goals. Some of them thought about creating a second half plan or a stubbier plan. But there were concerns with that because their goals were already underwater. And they thought, well, at this point, we don't know what impact COVID's going to have on the second half of the year. And if we reset goals, there was a chance that you could miss the reset goals as well, and then have to apply discretion. So most of our clients decided to also, under the hard hit category, take a wait and see approach. There were some exceptions depending on facts and circumstances. One of my clients in particular last year, their bonus plan for 2019 did not pay out. And so they were already facing retention issues. So when their goals went south for the first half of 2020, they decided to implement a six-month stub plan rather than using discretion at the end of the year, because they felt like having something in place for the workers to work toward would be more retentive than just saying, trust us, at the end of the year, we'll take care of you. And in this particular case, it's been working out pretty well. They shifted from financial goals to looking at product mix and cash and liquidity goals, so non-traditional financial goals. And they reduced the total incentive payout so that the maximum they could get would be their original targets. Overall, in shifting from the annual incentives, when we look at the long-term incentives, overwhelmingly, companies are not considering making discretionary adjustments to their outstanding long-term incentives. There is a greater risk in doing that in terms of getting criticism from the proxy advisory firms. And there's also additional disclosure and accounting implications, especially if the discretion or the changes would be considered a modification and appear to be a re-grant of the long-term incentives. We are seeing that some clients are making focused retention awards, generally to those executives below the named executive officer level, so that they can avoid the disclosure in proxy statements, but still retain executives that hopefully from getting poached. Next slide, please. So about the middle of the year, we polled a lot of our clients and asked them what they were going to be doing with their bonus plans, if they were willing to consider discretion at the end of the year, or if they were going to stick to their regular formulas. The most common approach that our clients indicated is that they were not going to be making changes to the bonus plans, and that they were going to be open to using discretion at year end. Overall, approximately 66% of our clients indicated that they were open to applying discretion, and about a third said that they were not going to be considering discretion, but relying on either the original formulaic plans or a new formulaic stub year plan. Next slide. So this matrix that we have on this slide is a discretionary framework that we've been using with several of our clients to help them work through their argument for applying discretion at year end with compensation committees. So some of our clients are taking a focused approach where they're saying we're going to exclude certain quarters within our fiscal year, for example, maybe Q2 or Q3, and just look at what our bonus payouts may look like before the pandemic and now this last quarter during somewhat of a recovery. But many of our clients are saying we can't even do that. It wouldn't produce a payout, and we need a different way to assess discretion. And so the approaches they're taking, they're looking at what the initial projections were against their original plan, as well as if they adjust their results, how that could look like, excluding some of the impact of the bad quarters. They're looking at what their absolute stock price looks like and whether or not that has shown a recovery. In some cases, the recovery at this point for companies, the TSR may be about -25 or -30%, which still would not give much support for discretion. But then in other cases, if stock price has recovered to slightly negative to positive, then there's a lot more support for applying discretion. In those cases where if TSR hasn't fully recovered, companies are looking at other relative comparisons to peer groups. So if your TSR is negative, it may be that in a relative basis, you still look good against your main competitors. And also, if absolute financial performance may not look great, on a relative basis, you could still look good on growth and margin and other different financial factors. Part of the narrative also is the qualitative performance that the management team has been able to achieve. So looking at employee engagement and safety, consumer retention and satisfaction during this time. What was management's initial reaction to the outbreak? How are current projections looking against analyst expectations? And how did the company respond to other ESG related factors during the year, such as diversity and inclusion, or possibly other human capital factors? And then finally, there's other considerations as well that companies have to consider when applying discretion, such as what are the internal optics? Have companies hired back employees? Have they reinstated dividends and 401k matches? What has the shareholder experience been? Even if financial performance isn't good, if TSR is positive, that's a mitigating factor. What are the potential external reactions from proxy advisory firms, as well as the press? Larger companies with much more scrutiny will have to worry about how the media may react to their decisions. And then also just the basic company health. Does the company still face liquidity concerns, debt burdens, and so on? And then finally, in addition to all this, there's other considerations such as what have the annual bonus payout plans look like in terms of the payouts the last 10 years. For some of these companies, the last time they received a low or zero bonus payout may have been back in 2008. So some companies are saying this is our year. It hasn't been in a while, but this is our year to take another goose egg. Additionally, some companies may be facing much more poaching efforts than others. And so those companies may not be able to grant retention equity, but at least through the bonus, they can ensure retention where sometimes cash can be king. Okay, next slide. So now we're shifting gears to some of the conversations that we're having for 2021. So depending on the industries, those hardest hit industries, we're not seeing companies projecting base salary increases. But for other companies, we're seeing merit increases of approximately 2 to 2.5%. As far as board of director compensation, generally it's really a facts and circumstances and how companies are reacting with the executive team. So if executives aren't receiving bonuses, if the company's outlook still looks poor through the end of this year, then generally the board of directors are not recommending increases to their programs. But if companies are on the way to recovery, and if they're first looking at making their board recommendations at the end of the year, then they may consider slight increases to board pay. As far as annual incentive design for executives, companies are recognizing that there's a lot of uncertainty in the goal setting process for this upcoming year. And so they're taking the following strategies in setting goals. So some companies are adding metrics to their bonus plans. In several cases, it might be that they're taking their traditional financial measures and adding some less traditional measures to go along with it. Like, for example, in the example I mentioned earlier, the company who implemented a stub year, for 2021, they're going to be going back to their financial measures, but they're also going to be adding in some of the different measures that they are using in the 6-month plan, such as looking at the rebalancing of where their product lines are focused. Some companies are widening their performance curves to dampen the impact of volatility. So for instance, if you're normally setting the cut-in for threshold payouts at 95% of target, they may lower that down to 90% of plan or budget for a threshold payout. But on the upside, what they're doing is they're making that a little bit harder for a payout. So if a maximum payout might be at 110% of budget, they would increase that to 115 or 120%. Additionally, around target, they're recognizing that there's not much certainty. And so some companies are setting target payouts at a range of possibly -2 to +2 or -5 to +5 around target, so that there's a much easier chance to get a target. Some companies are using more discretion in the form of strategic measures or individual objectives. And so those who already have strategic measures and individual objectives are increasing the weighting from maybe 15 or 20% up to 30. Others are considering adding that for the first time. And then other companies are considering delaying goal setting until volatility dampens. Finally, one approach that we've heard from one of our restaurant clients is that they're considering a semi-annual approach to 6-month periods for 2021, with the thought that until the vaccine hits, the first half is probably going to look very different than the second half. And so they're expecting the second half to be business as usual. Next slide. This page just illustrates an example of broadening the payout curve. So you can see that the curve on the left shows a normal 2020 curve in which the company used -5% of budget for a threshold payout up to +5% of budget for a maximum payout. And broadening the curve out, they're now going from 92.5% of budget up to 107.5%, which you can see with the red arrows. And this company is also setting what we call a landing pad, where a target payout would suffice for anywhere from 2% below budget up to 2% above budget. Next slide. Within long-term incentive plans, some of the strategies that compensation committees have been focused on are switching over to using 3 one-year performance periods rather than a 3-year cumulative design. They're considering increasing the use of relative performance. So for some companies, that might mean adding relative total shareholder return. For others, they're considering using relative financial metrics such as relative profit growth. But one caveat is for those companies, there is a delay in the reporting of financial measures. So while you may know for a particular company what your performance is through a 3-year period, there will be a quarter lag in disclosure from those peers. So that has, in some instances, dissuaded companies from considering this approach. And then other companies are considering lowering their weighting toward performance-based LTI and either increasing the use of stock options, which have a higher time horizon, or shifting some of their LTI into time-based awards like restricted stock. Next slide. This slide is just a reminder that I've been focused pretty much on incentive pay and COVID's impact on that, but there's also been a slew of other pay and governance issues that have occurred when COVID hits. So as CEOs got sick, this cast a spotlight on certain companies who may not have great succession plans in place. And for another example is with stock ownership guidelines. Some of those companies who had several executives fall out of compliance considered removing their time for compliance requirements and instead put in place retention ratios. So instead of requiring executives to purchase shares to meet their ownership guidelines, they just couldn't sell any going forward. Okay, next slide. I'll hand this over to Andrew, who's going to discuss the legal and tax considerations for these different pay actions.
Thanks, Michael. So as Michael indicated, there are some important legal and tax considerations that your company should keep in mind whether you're considering adjusting the plan terms itself or exercising discretion. And that's really true whether or not we're looking just at a formulaic plan or even, salary levels. Chief among those things that you should do are reviewing plan documents and agreements to make sure you're not avoiding, or excuse me, you're not to avoid violating any contractual terms or triggering unwanted events. So first, if you have a contractually obligated salary, for example, it's going to limit your ability to adjust that downward without potentially exposing yourself to a breach of contract claim. As Allison noted, employment litigation has been down, but we do expect that to rebound in 2021. And so obviously you'll want to consult with legal advisors if those are changes you're considering, particularly if you have an agreement or plan that's ambiguous in its language. Another reason to make sure you're looking at those terms are for a lot of senior executive contracts, a lot of them will provide that the executive can terminate employment for good reason, and usually diminution of compensation opportunities is part of that definition, even though the definitions will vary from company to company. And in that instance, you're going to want to evaluate what are the consequences of that decision. Are we triggering severance benefits? Are we potentially accelerating the vesting of equity awards? Are we limiting the scope of restrictive covenants? Second, you'll probably want to evaluate any impact on under Code Section 409A, which has wide-ranging rules for what is considered deferred compensation as defined in the statute. Now, generally, we're not concerned there with compensation that is fully discretionary, such as a bonus that your company decides to give an employee and it's fully discretionary at the end of the year. Instead, we're concerned with things that an employee will have a legally binding right to in 1 year that would be paid out in the next. And in particular, if you've adjusted the deferred compensation and now you're thinking of modifying in some way, there could be substitution rules that come into play that limit when that payout can happen. So again, because there are significant consequences for the employee if 409A's rules are violated, you'll want to consult with legal advisors as you're considering and making those decisions. In addition, it's important to consider any golden parachute rules and impacts under Code Section 280G, which generally defines an upper limit for certain classes of employees and potentially shareholders for compensation that is conditioned on the occurrence of a change in control transaction. Again, you'll want to evaluate the impacts of compensation adjustments in advance because the way that it is, the 280G is calculated, it basically means if you're downwardly adjusting compensation this year, you have the potential of lowering how much they can be paid out in the future. And given how some senior executive employment agreements are written, you actually could look at subjecting more of that potential payout later down the line to an excess compensation that would be potentially non-deductible for your company and also subject to excise taxes for the employee. Michael referenced this a little bit earlier too. There are disclosure requirements for public companies to keep in mind as you're considering and making any of these kind of adjustments. Obviously, proxy season is nearly upon us again, and any adjustments to compensation, particularly for your named executive officers, is something you're going to have to discuss in the proxy. So it would be good at this point to start determining how are we discussing those things in a favorable light considering the circumstances, but that's also fully accurate and explanatory to your shareholders. And then as well, keep in mind, what is ISS, what are Glass Lewis and other proxy advisory firms going to think about your explanation and what the underlying changes are. In addition to that, it's important to keep in mind beyond your proxy that depending on the nature of the compensation changes you're making, you may actually trigger a need to file a Form 8K, which generally, if you enter or make a material modification to a material compensatory plan arrangement or award, could come into play. Now, that's not a hard and fast rule. So again, it's important to contact and consult with your legal advisors about that, but do keep it in mind. And then finally, for public companies, also consider any impacts on grandfathering under Code Section 162M. Now, we certainly see less and less of that as the further away we get from the Tax Cuts and Job Act's effective date. But generally speaking, if you have any arrangements, particularly performance-based compensation arrangements that are still subject to that grandfathering rule, you'll want to evaluate whether the changes you're making could be considered a material modification. And then finally, evaluating any impacts on stock ownership guidelines. So for most companies, this is probably set as a specific number of shares. And if you are reducing your future equity grants, it could hinder an executive from meeting that from that guideline level. In addition, if you've had a decrease in your share price and your guideline is written or denominated in a dollar amount, again, you could see that impact. With respect to non-employee director pay, moving forward, we fully expect that non-employee directors may want to see increases. They've been asked to do more and more since the recession. Obviously, there's a lot of work doing the pandemic and ESG, which Andy and Dave are going to touch upon shortly. And so it's important to keep in mind that anytime you're making adjustments to your non-employee director pay, those decisions are subject to a very strict entire fairness review, which looks at not only the fairness of the compensation itself, but also the process by which the decision to adjust that compensation was reached. And so the key here is you'll want to take steps to mitigate risk. So make sure you're appropriately documenting all decisions. And that's true even if the decision is to maintain your current compensation level. It doesn't hurt to have a record of those deliberations just in case a dispute later arises. You should consider going to your full board for any alterations in non-employee director pay. And you also may want to consider obtaining shareholder approval in certain circumstances that may it may preclude litigation down the line. But again, if you have specific concerns with a decision you're considering with that, I would encourage you to reach out to your legal advisors because again, there has been a lot of litigation in recent years around that standard. I will hand it now back to Michael.
Thanks, guys. I think you've done a fantastic job of highlighting the data and showing us where things have gone and highlighting some of the risks and things that companies should be keeping in mind as they're looking at making these sorts of changes. So now we're gonna switch gears a little bit and we're gonna turn back to the employment side of this. And we're gonna ask Lynn Mapes Reardon to bust out her crystal ball and tell us what might be on the horizon with a Biden administration. Lynn is my co-chair of the Compensation and Employment Practice Group at Ferrazzano. She is an employment counselor and an employee benefits lawyer, so she has a broad spectrum of experience. She also oversees our firm's human resources function, so she has insight from the operational side of it as well. With that, I'll turn it over to Lynn.
Thank you, Andy. Let me first assure everyone that I'm okay. The black eye that you may see as a result of a scuba diving mishap I had in Cozumel last week. So it looks a lot better and feels a lot better than it did just a week ago. As Allison mentioned, and Andy also mentioned, this segment tries to look at employment law and look into the future. I'm going to assume that we will have a Biden administration. Otherwise, I could cut this off and say, we'll just have more of the same of what we've had for the last 4 years. Instead, what I think is we're going to see many attempts to change where we are right now. What we should expect to see a Biden administration do is to reverse Trump era, especially look to reverse Trump era executive orders and regulations in the employment area. And those orders were in great part a reversal of the Obama era executive orders and regulations. Obama used executive orders regularly to achieve policy goals, and Trump continued that practice. I'll also note that the Trump administration is working very hard during what is called a lame duck period. That is the period between the election and a change in administrations, as it is expected. So this can pose challenges when a new administration is clear that it will work to reverse even final regulations. So while this may feel a little bit like a game of ping pong, it has real life impacts on how you run your business and the choices you make. So let's look at some of those areas that the Biden administration has articulated that it wants to see changes. I'll note that I'm not really presenting these in any particular order of priority. And anything that requires legislation may be dead on arrival, as we all understand it, dead on arrival in the Senate, unless the runoff in Georgia goes the Democrats' way. And so I may have a crystal ball of certain strength. It doesn't get that far. So nonetheless, as I noted, presidential executive orders and the regulatory power that resides in the executive branch can meet many new policy goals. So let me take it back a minute, just what I said about priorities. It's clear that the pandemic is going to be the Biden administration's first priority. It has said so. What will that mean for employers? In the interest of time, I'm going to speed through some of this. Expect that you will see mandated requirements for safety in the workplace from OSHA. I'm not sure what they will be. I have to believe that they're going to involve masks, social distancing, and barriers. I also think that we need to look very closely at what the CDC and the approach it takes. I suspect it'll be revitalized, and it's going to take a much more directive approach. Now, its guidance is non-binding, unlike OSHA has enforcement powers. But that non-binding guidance that CDC will give, especially to the extent it's much more directive, if you don't follow what public health officials' guidance is, you can expect to be defending COVID-related lawsuits and talking to Allison more than you're talking to me. Another area that the Biden administration will look to strengthen employees' security, wage security, and benefit coverage is one that has had incredible and intense interest in the last several years. And this is the question that the gig economy brings into stark relief. What jobs are those that employees do? And when can those jobs be performed by the same person, but as an independent contractor? As an independent contractor, it's less costly to engage that worker. Currently, employers have multiple tests, even for determining who's an independent contractor, the default being that you're typically going to be deemed an employee. You have to prove that the person is an independent contractor and satisfies these various tests. Think of the DOL and its tests. That involves minimum wage and overtime. IRS has its own test, slightly different. Think about your employment tax liabilities. This past September, and I'm going to try to go through this very quickly. The Trump administration basically took the DOL's economic realities test and its 5 factors and said, rather than evaluating all 5 factors more or less weighted the same, identified the 2 control factors as more important than, or core, than the other 3 factors. Now, again, not to try to get in the weeds here, the bottom line is that I see the Biden administration trying to get some uniformity in this area and moving towards what many of you may already be familiar with, which is called the ABC test. Now, many states use this ABC test and state unemployment agencies use it. So as employers, you're regularly accustomed to, okay, what's the most stringent standard? Just, I will satisfy that. So to the extent that the Biden administration can implement the ABC test across the board at the federal level, you will find yourself being consistent with what many states do. Another area that has had much attention as our economy changes the way it engages employees. Many times I can run a business, but those employees really aren't my employees. They're employees maybe of a staffing agency. The question becomes, can I be liable for people who are not on my payroll? They're on the staffing agency's payroll. And that's the question of joint employer. So that question, both from the Department of Labor when it comes to Fair Labor Standards Act, remember minimum wage and overtime concerns and potential liabilities, and the National Labor Relations Board, think about potential liability for unfair labor practices. Again, the Trump administration tried to move the rule to one where we focus solely on the control that the employer has over the employee, including pay determinations and day-to-day working conditions, which would tend to separate companies from each other. The NLRB has taken many twists and turns through its own agency and through the courts. The bottom line here is that I would expect that a Biden administration would, one, try to change regulation, and it will have a lot of influence over the structure and the membership of the NLRB. And we may see changes more down the road on a standard for determining joint employment. Let's see. We also had a change in the standard for when employees, even when they're engaged in concerted activity to improve their terms and conditions of employment, as Allison reminded you, the private workplace, non-union workplace is still subject to these rules. There's been shifting approaches to when employee conduct is when they make offensive comments, racial nature, sexual nature, is something that you can fire the employee for and not risk an unfair labor practice, even though they were engaged in concerted practice. Again, I expect a Biden administration to be somewhat more protective of employees, and this is always a balance of employer rights to regulate the workplace and employee rights to organize and to work to improve their terms and conditions of employment. Related to that, the PRO Act. This would require legislation. And fundamentally what it would do is make it easier to, for workers to form unions. It would take the impediments to organizing out of states that have so-called right to work laws, and outlaw the use of class action waivers in arbitration agreements. And it would also codify the joint employer rule I mentioned above. Again, this may be dead on arrival if the Senate remains in Republican hands. Similarly, on pay equity and transparency, there's legislation, the Paycheck Fairness Act, which will ask for increased information about your compensation practices. The EEOC by regulation, so it would not require legislation, will likely look for that compensation information again, probably broken down by both sex and race. I'll note that when it comes to federal contractors and the fight for $15 per hour, which has really been taken up more at a local level throughout the country, a Biden administration can do a lot by executive order here. Obama did it incrementally. He increased it to $10.10. And it's always been the case, if you don't comply with those laws, you could lose your federal contract. Trump did that, but I expect that to be again reversed, and your contract will always be at risk if you don't comply with labor laws. And so I think Biden will try to inch up that federal contract required minimum wage. This is related to the ESG, the diversity training. This is going to be near and dear to the Biden-Harris administration, where they have at their website included a multi-page plan for combating racial inequality. They have a commitment to, quote, making systemic changes to address discrimination and harassment in the workplace. This commitment is consistent with elements of the ESG that we talked about in just a moment. So the reason this came into stark relief recently is that the Trump administration issued an executive order that impacted diversity training at federal contractors that had the effect of stereotyping based on race and sex. There was a lot of confusion about what this means. The director of the OFCCP had to walk back some of what the executive order says, and many companies have said, I'll wait to see in doing my diversity training how this plays out, because I don't want to risk my federal contract. I just can't do that. But whatever the result is, companies, especially public companies, should continue with their diversity training at DE&I training at their companies. I note that it should be tailored to your organization and tailored within your organization based on the varying levels of responsibility for DE&I outcomes at your company. For example, I've been training boards, senior management, boards of directors about their particular roles when it comes to DE&I. They're not always making direct employment decisions, but they certainly set the tone at the top. I'm going to skip over the retirement plan changes. Just note that next year, you're going to have to start tracking your part-time employees with your TPA in ways you've not had to in the past. And then expect that we could see some bipartisan, this is truly an area of retirement security and saving, that there is bipartisan agreement and cooperation, we may see a Secure Act 2, which would have employees default into making contributions out of their own money. They can opt out, but the default being that they're participating in the employer's plan and making contributions towards their own retirement. Thank you. And Andy, I have left time.
Oh, yes, absolutely. Thank you, Lynn. That was very, very insightful. Thanks for dusting off the crystal ball for us and trying to help us figure out what might be coming down the road on the employment side of it. So for this last segment, we're going to spend some time talking about the ESG phenomenon that seems to be changing everything, including the way that you compensate your employees. Joining me for this last segment is going to be David Yang. Dave is a managing director in FW Cook's Chicago office, and Dave has over 2 decades of experience advising companies on all aspects of executive and director compensation. His experience covers a wide range of companies, from pre-IPO companies to Fortune 100 companies, across a variety of industries, including financial services, healthcare, retail, transportation, and technology, and I'm sure there's other ones in there as well. So Dave, thank you for joining us today to talk about this topic. We have a few minutes to get through it, and I think maybe in those few minutes we might decipher what just ESG stands for. Environmental, social, and governance. Even the title of this phenomenon sounds daunting. And I can tell you, when especially this year seems to be almost a microcosm of all of this. We have a global pandemic. We have political disagreements. We have wildfires in California. We have all kinds of stuff going on that it looks like society is looking to companies in many ways to help them fix this. And so it's become a big issue for the boards. And so when we see I'm watching TV or the news with my boys, and we see these stories, and they look at me and they're like, well, what's all this about? And I have to admit, my first reaction is kind of my breath is taken away, because I've been reduced to the status of the guy who knows nothing in my house by my boys. They're that age now. But then when I stop and think about it, at least to me, I look at it and I think, well, what society is asking companies to do is to be ethical, to be reasonable, to be responsible. And while this may have started as some kind of political thing, we now have business leaders from all over the world who are saying, companies, you better pay attention to this or your futures may be doomed. So with that, how Dave, when you go into these meetings with management, when you go into these meetings with a board of directors, how do you try to help them distill down this issue and really make it something that they can focus on, that's workable? What do you think about that?
Yeah. Well, first of all, thank you, Andy, for inviting us to this webinar. To answer your question, you got to remember, Michael and I are compensation consultants, and our clients are the compensation committees. So by the time ESG topics get to us, the question becomes, should our incentive systems reward or penalize our executives for poor or insufficient ESG performance? So that's just a way of saying that this issue of ESG has been it's been in the market for multiple years now. There is a slide, the next slide, page 33, where we talk about the catalysts behind ESG. I won't go through all of them. I think this audience probably is familiar with a lot of these, but there's definitely a shift in the marketplace towards what the responsibilities of the board, what the responsibilities of management are to its shareholders, to its communities, and all those others it makes to society. And so that's been around, and it's been a topic that boards have been dealing with for multiple years now. So we're kind of at this point in our life where it's starting to get pushed into the comp committee discussion to say, okay, look, we understand, here's our initiatives, here's our strategy, how do we make sure that our team is focused on meeting the demands of this new plan or this strategy. And that's kind of where we are today. And so I know we don't have a lot of time left. I just want to make sure the audience knows that in this material, which I believe is going to be distributed, we've included some data around what companies are doing in terms of their incentive programs. The key takeaway from this is that there is no single answer right now. Companies are feeling the pressure to at least identify ESG type metrics in their compensation disclosure and reflect it in their plan. But how they're doing it today is very soft. Very few companies are utilizing hard measure goals with well-defined metrics on a formulaic basis. A lot of it comes down to looking at it from a kind of qualitative lens and evaluating whether or not progress is being made. And again, for the compensation committees, a lot of these ESG topic areas are not, the idea of being rewarded for doing the right thing is kind of an odd concept. So compensation committees have to spend time evaluating the various components of their ESG plan and seeing, okay, what falls under the header of just doing the right thing as an organization and making sure that we reflect best practices and operate at the highest level with the highest level of integrity and ethical standards. And then there's the other side, which is, okay, which of this stuff is not necessarily best practice, but rather from the standpoint, from the position of improving our responsibility to the community. So that's kind of where the discussions are nowadays. And again, there is the data. Again, for the audience, the data is in the deck, and it's pretty self-explanatory, I think. But as I would just say, the key takeaway here is there's no. If you feel pressure, if your companies feel pressure to adopt, there's no one way to do it. And number two is it don't automatically have a knee-jerk reaction to the fad of adopting ESG. Make sure it's a well thought out plan, because if it has incentive implications, we want to make sure that there's no, there's no perverse incentives inadvertently put into place. So
yeah,
I'll leave it at that.
On that point, to the extent that we're talking about public companies, once we put those into our incentive plans, we have to worry about the disclosure obligations that go along with that. And, the public companies are all familiar with their proxy disclosure rules and using the CD&A to tell a good story about incentive compensation. But there's certainly a risk there that if you go out on a limb and say, we are going to compensate for X, Y, and Z under our ESG ethic or ESG program, and you disclose it and you don't hit it, I'm not a guy who uses a whole lot of social media, but especially in this day of Twitter and whatever else, you run the risk of becoming the next big thing on the news when everyone says, well, did you see all those people who retweeted that story? Or did you see all the, even now I'm failing to come up with different apps that you might use to get the news out, but you guys get the picture. There's really a reputational risk there. There's company performance risk there if you are not living up to what it is that you're disclosing. On the other side of that, though, I think on the disclosures, you really have the opportunity to tell a really positive story and really get buy-in from a whole lot of stakeholders in the company. So with that, I see that we're at the end of our time, unfortunately. I would like to thank Michael and David for spending so much time preparing for this presentation and spending some of their valuable time with us today. I would like to thank all of my other presenters for the same thing. It's not an easy undertaking getting ready for one of these things. I'd like to thank all of you who have come out and spent some of your day with us. And hopefully we've been able to provide you with some food for thought as you begin to look into 2021. A couple of house cleaning items. CLE credit is pending, so we will be in touch with you. If you need CLE credit, we'll be in touch with you to tell you how to go about getting that. There will be an email distributed to all registered participants that will include a link to a recording of the presentation and the PowerPoint. And at the end of the PowerPoint, there is contact information available for anyone on this presentation team. So you should feel free to reach out to any or all of us And if, to the extent you have questions, we're happy to address them. We will go back if there were any unanswered questions that came in through the Q&A on Zoom. We'll go back and make sure that those are addressed as well. And with that, we hope you all have a wonderful and safe Thanksgiving. And if you're in Chicago, go outside and enjoy some of this beautiful weather. Thank you. Have a great day.